Hello, hello. All right, good morning and welcome to another episode of the Liberty Dad Podcast, a discussion on politics and culture. I'm your host, DL, America's most objective libertarian. If you're tuning in live, thank you so much for giving me your time so early. Now, remember, folks, this show does not run on freedom fumes alone. If you're watching me on Rumble, smash that green $ button during the show to drop a Rumble rant. It's kind of like tossing me a cold one at 7:30 in the morning because, yeah, that's how we do it, right? Anyway, so it's a way to help out the show. It keeps the vibes high, the mic's on, and if you really want to go all in, then click subscribe for $5 a month. Your support helps me fight the good fight. All right, let's get into it. I believe we are past, at least for now, the audio issues that we were having yesterday. I'll just be straightforward. I think there might be some settings that I need to readjust here, but keep me accountable, folks. Let me know wherever you're watching from, whether it's on X or Facebook or Rumble or YouTube. Just let me know and drop me a line. Say, hey, I can hear you really well, what have you. Those kind of things help me out, especially during the show, because then maybe I can click on a few things potentially, or just at least have an idea of what I need to go back and review. Anyway, we're going to talk about Judge, I think it's Immergut. That's what I'm going to go with. Okay, Judge Immergut. And a lot has been made of this judge. Plenty of social media personalities have made her out to be some radical leftist judge trying to destroy our nation because she hates America and she just hates Trump. Well,
we need to get into some facts about who this judge is. So let me show you this first image here. I only have this one particular image, okay? This is Matt Walsh, our good buddy Matt Walsh over there at the Daily Wire. He's got like some 3 million followers. That's cool. I ain't mad at him over that. But when he says something, quite a few people see it. So what did he say? We have long reached the point where Trump needs to openly defy these judges. Some random federal judge has no authority to decide how and if troops are deployed. She is not the commander-in-chief. Ignore her and deploy them. It's time for a showdown with these activist judges. All right, Matt. Well, we're going to test that out. We're going to see if she is actually an activist judge. So a couple facts that you may not know about this judge. She was nominated in 2018 and then I believe again in 2019 by who? If you said Donald Trump, please go to the head of the class, because she in fact was. Now you might think, okay, well, some people tried to make the argument. They're like, well, Trump acknowledged that he had some bad picks. Okay, why is that my fault? Why is that he picked bad some time ago, and so today he gets to just ignore judges and say, nope, I don't have to listen to you. I don't have to hear what you had to say, right? Like that's where we're going. This is kind of weird coming from the right, because they're whining and crying about, rule of law and all these, judges are just defying the law and doing whatever they darn well please. And then they turn around and they're like, but our guy, he should do whatever he darn well pleases. Oh, okay. Continuing on here. She was voted in Judiciary Committee 20-2 by a Republican majority. Did you know that? Bet you didn't. Because, your influencers out there, they're not telling you these kind of facts. I am, though. I will bring you the straight up facts, because I am the most objective libertarian anywhere in America. She was also confirmed in the Senate by a unanimous voice vote. Also a Republican majority. Now, he wants to call her a random judge. Her district, did you know her district is Oregon? It's Oregon. That's her district. Now, some people might argue and say, well, this judge shouldn't even exist. Perhaps you could make that argument, but you'd have to go back to I don't have it pulled up. Can I pull it up? Let me go ahead and see if I can't pull this up. And then, because I tweeted it out the other day, and let me see if I can't just scroll back through and find, let's see. Yeah, no, is this one? Nope. Is it that one? Nope, that's not the one I want. Let's go back a little bit further. Let's see here. Oh, let's see. Where is it? I know I had put it out there where, let's see, there's that one. Oh, yeah, here it is. Congress organized Oregon as one judicial district with one judgeship. The District Court of Oregon, not being assigned to a judicial circuit, was granted the same jurisdiction as U.S. circuit courts, except in appeals and writs of error, which were the jurisdiction of the Supreme Court. So basically just like a step below the Supreme Court. Well, okay, that may not be accurate. There may be like a more, a district court like oversees it. But this was in March 3rd, 1859. So if people want to make an argument and say, well, she shouldn't even be a judge, there shouldn't even be a court. Well, talk to Congress in 1859, who followed the law and created that court. Okay? All we're doing is we're validating whether or not the judge is random and whether or not there's any reason for the average person to believe that she is, that this court has the authority that it does to make this ruling. Okay, so the district is in Oregon. Now, you might remember back in episode 483, SCOTUS's ruling on Venezuelan deportations, that I pointed out that SCOTUS had ruled, the Supreme Court ruled, that Texas, where the individuals were detained, this is talking about the people that got deported, remember all the immigrants that got deported to El Salvador, that they ruled that Texas was the appropriate venue, not D.C. Now, in that instance, what happened was the legal representation for the detainees tried to file in D.C. rather than Texas because they felt D.C. was a little bit more a sympathetic court. We don't know that for a fact. That's not what the Supreme Court said. They just said, hey, you have to do this, the proper district would be Texas where they're detained, not D.C. This was at the Trump challenged this, okay? And the Supreme Court agreed with them. They basically said, no, you have to file where they were detained. Okay, so once upon a time, basically what I'm saying is that the Trump administration argued that, hey, this needs to be within the scope of this district where they're detained. Now, there may be no legal connection. I'm not a lawyer. I'm just a guy that reads. But as a simple reading for the average person, it makes sense that people seeking court oversight should seek it in the same jurisdiction for which things are happening, right? And the Trump administration was on board with this. So I look today and I say, well, he was trying to send troops to Portland, and a district court that oversees Oregon, the whole state, they ruled and said, yeah, there are some problems here. We're going to give a temporary restraining order. The Trump administration squawked and complained and cried about it, right? So it's like, well, from the average person's perspective, that seems as legitimate as when the Supreme Court said, sorry, these detainees, that filing, that must be in Texas, not D.C., right? Now, again, this is just a lay person reading from an average perspective, because the idea on this show is that with a little bit of reading, you can be much more informed. That's kind of like the whole point of my show. I go and I do all the reading, and then I kind of give you my perspective of it. I may or may not be correct. However, I seem to have a good track record because my reading skills are pretty decent. Okay? And so I'm just demonstrating for you that, as an average citizen, because think about it, Trump, who does he answer to? Us, the people. Who does Congress answer to? Us, the people. Judges do not, but judges are appointed by the people that answer to us. Okay. Now on the a local level, there are situations where they are up for a vote. Okay, and that's an entirely different conversation to have. But my point being here, if we want to be a populace that maintains our system of government, the United States of America, this experiment that we're in, what do I always tell you? What's that quote from Benjamin Franklin? He gave us a republic. If we can keep it, how do we keep it? We stay informed. And even if we're not lawyers, we can still make heads or tails and at least get close to being correct, if not actually being correct. And all it takes is a little reading. She's also a FISA court judge. Now, that doesn't really bear any, that doesn't have any reflection on this particular case. I'm only pointing out that when you're a FISA court judge, when your district is Oregon, when you are confirmed in the Senate by a Republican majority, when you are confirmed in the Judiciary Committee by 20-2, also a Republican majority, when you were nominated by the man that you're pushing back against now, the influencers that are like this random judge are wrong. It's not a random. They make it out like we just picked up a judge anywhere we could find and said, you know what, I bet this judge is going to rule in our favor. Like, where else would they, if somebody wanted to challenge the fact that Trump was trying to bring troops in, where the hell else should they go? Who else should they get? Right? I mean, they complain about Democrat appointed or nominated judges. Why aren't they, and then they complain about the Republican ones. Who else can nominate them? I mean, if you, we'll say it like this. if the influencers out there, if the public out there is mad about Republican appointed, or I'm sorry, nominated judges and Democrat nominated judges, by all means, stop using lawfare to keep libertarians off the ballot. We will appoint judges. You won't like them any better, but, you know, get us in there. We will nominate some judges, and then you can, you know, bitch at us too. Yeah, but do you see the point here? Like, these arguments don't make sense when you just spend just a little bit of time thinking about them. Now, let's see, where do I go for that? Yeah, is it this one? No. Here, no. Let's see here. I was trying to think of where. There it is. That's where I want to go. Let's do this. Let's put this up on the screen here. There we go. So I want to read from a little bit from this article. Okay, so this is from the Oregon Public Broadcasting. All right, I'm going to read some things to you. Let's see. We'll zoom in on it a little bit so you can see it a little bit more better. All right, colleagues say Oregon judge who blocked Trump troop deployment is well respected and has no fear. It's interesting. Former colleagues describe Immergut, I'm going with Immergut, as exceptionally qualified and not influenced by politics. Oh. So we'll just stay right here for a second. Who knows more about this judge? Former colleagues or Matt Walsh? Who can bring you the truth about who this judge is better? Matt Walsh or colleagues? The right loves asking questions, right? I'm just asking questions. Let's read what they have to say. When President Donald Trump criticized U.S. District Court Judge Karine, I don't know if I'm saying her name correctly, Immergut, on Sunday for blocking his deployment of 200 members of the Oregon National Guard, it was evident he didn't know who she was, despite having appointed her to the job. They're quoting the Trump. I was going to say the Trump administration. They're quoting Trump. That judge ought to be ashamed of himself, Trump told reporters on the White House lawn. Oh, now look, I don't care about misgendering, right? If we're talking about a trans person, you can get over yourselves. We've talked about that before. But I'm just going to say, if you're criticizing somebody and you don't even get their gender right, particularly when this is not a person that has some confusing gender identity, right? Like Immergut is a woman, and presumably she identifies as she, so therefore all the standard practices apply there. So if you misgender somebody who doesn't have any confusing, maybe you don't even know who you're talking about yourself. So how is the president going to come out? He is supposed to be the leader of the free world, and he doesn't even know who the judge is that is put a temporary restraining order on him. He just like he ought to be ashamed of himself. Maybe Trump needs to be ashamed of herself for not knowing who himself was referring to, which was actually a herself. Did I make it confusing enough? I'm trying to be clever at 7:53 in the morning. We'll go with it. Anyway, misgendering aside, Immergut's former colleague said Trump's assessment couldn't be further from the truth of who Immergut is. You don't know Karine Immergut, former U.S. Attorney Billy Williams said of Trump, and I do, and so do a lot of other people. She's very well respected. Former colleagues, including judges and federal prosecutors from across the ideological spectrum, describe Immergut as exceptionally qualified, immune to political influence, and versed in high-stakes cases. Her work has riled Democrats and Republicans alike. Let's just stop right there. If there is a type of judge that's going to get my approval, even if I disagree with them from time to time, it will be somebody that has a reputation for angering the Democrats and the Republicans. That is their job. Their job is to look at the case, look at the evidence, compare it to the Constitution, or whatever laws are applicable and judge earnestly, objectively, and with wisdom, which means, yes, you're going to piss off Democrats sometimes. You're going to piss off Republicans other times. In the 1990s, she investigated President Bill Clinton as part of Kenneth Starr's team. And as judge in 2023, she ruled against sheriffs and gun advocates who argued Oregon's gun control laws violated the Second Amendment. All right, so there I would give her a fail on that one, okay? Because in my opinion, any gun control law, every one of them, would violate the Second Amendment. So I would disagree with her on that. But she investigated President Bill Clinton, and then she, so that was like a win for Republicans in a sense. And then she ruled against sheriff and gun advocates. Okay, so that's a win for the Democrats. So now we have actual case law that shows that, yes, she pisses off both sides. Okay, great. And she's pissing off libertarians with this gun control. But that's not what we're talking about. We're just laying out who this judge is. She's an honest and careful reasoner and absolutely committed to the Constitution, said Oregon's former federal public defender, Lisa Hay, who has known Immergut for 2 decades. So 2 decades versus Matt Walsh, who I doubt has even heard of her before this moment. Okay? Hay argued cases against Immergut as a prosecutor and before her as a judge. So if I'm a lawyer and I'm arguing cases against another lawyer, and then I argue them before that person as a judge, and then I've known them for 2 decades, and then I can say, hey, they're honest and they're committed to the Constitution, that seems to have some weight. When Immergut temporarily blocked the Trump administration's troop deployment, first on Saturday, then again on Sunday, the judge said it was because the facts on the ground didn't provide a legal basis for it. Oh. So that is something that you and me as regular people can read and say, is it true or is it not true? Right? This isn't, we're challenging the idea that this is all about activism. That doesn't sound like activist at all. The people claiming activism, they haven't made a case other than, boo-hoo-hoo. You ruled against my Trump man. Like that's your argument. We want Trump to do this thing. You said, no, you must be activist. Talk about anti-intellectual. Goes on, there's no showing that there's no showing that military help is necessary to protect law enforcement or the one federal building for ICE, Immergut told attorneys from the Trump administration. Okay? We can evaluate that. We can agree or disagree. And it's okay if you agree or disagree. Like if Matt Walsh had come out and said, I read the ruling, I disagree with her for these reasons, I would be like, okay, fair enough. That's a conversation we can have. We cannot have a meaningful conversation in this country when what you're saying is, where was that? Where did it go here? When you're saying that a random federal judge has no authority and that it's time for a showdown with these activist judges. What does that even mean, Mr. Walsh? What kind of country are you trying to create when you're literally saying, I want the president to do exactly what I'm saying the judges are doing, which is ignore checks and balances? That's really what he's saying. Trump, his deputy chief of staff, Stephen Miller, and many conservative voices have since painted Immergut as someone who isn't taking public safety threats seriously. And then it goes on and explains why they disagree. Let's get down here. I'm not going to read the whole article. In 2003, President George W. Bush appointed Immergut to be the U.S. Attorney in Oregon, the state's top federal prosecutor. Concern over terrorism threats loomed over her time in office. I spend a lot of time worrying as are we doing everything we can to make this area safe, she told the Oregon Bar Association in 2004. So in terms of like getting the mileage out of this judge, if you will, Republicans, the right people on the right, they got it. She was the top federal prosecutor and dealing with terrorism threats, and was concerned that they weren't even doing enough. But now they want to say she's not taking public safety into consideration? Based on what? What evidence do you have? I don't want to hear she ruled against Trump. That's not evidence. The evidence would be, and we're going to get into that after the break, the evidence would be, what are the facts on the ground? What is happening here? Where is she wrong in her opinion? That would be how you determine that she is out of line, right? That's how you determine that. Let's see, is that it? I think that might be it. Nope. When Trump nominated Immergut in 2018 to become a federal judge, she had the support of not only most Republicans, but also Oregon's 2 Democratic senators. Everybody screams about bipartisanship. Well, there it is, right in your face. Those are the facts. You can go back and you can look and you can see, did most Republicans support her? Did, at the time, Oregon's 2 Democratic senators support her? Those are facts that you can verify. I think that might be it. Yeah, that's it. Okay? So now we have a sense of who she is. So what does all this mean? Let's put it together. Critics of her ruling should be held to the standard of providing actual evidence against her ruling. That, like, if you, I'm cool with criticizing a judge in the same way that I'm cool with criticizing, a senator or a House member or the president or your local city council. There is not a single person in our government who I would tell you cannot criticize. However, I do want to hold you to the standard of criticizing them with evidence based on what they're doing or saying. That's what I want. I don't want your criticism just to be like, I didn't get what I wanted. We're not children, Matt Walsh. He has 6 of them. He should know better. He should know when it comes to governance, we do not act like children. His children will whine and cry, presumably, at times when they don't get what they want. I'm saying that because that's what my son does. That's what all children do. At some point, they whine and cry when they don't get what they want. That is not the standard that we should be expecting. Not from our government and not from our influencers. I don't care how big they are, or, in my case, how small they are. Okay? Claims that she's an activist, they should fall flat because nobody's presented any actual evidence. Okay? Consider that she was appointed in 2019. That's about 6 years ago. So remember, we ask questions around here, right? We're allowed to ask questions. Can her critics even say they've ever heard of her before the temporary restraining order? Can they honestly say, I've never heard of her? I bet most Americans never heard of her. Like, people in Oregon maybe did, right? Or people, if they were really following some of her high-profile cases, they might remember her. But for the most part, most people have likely not heard of her, or if they did, they may not remember because some of her high-profile cases were kind of a long time ago. But more to the point, before articles came out about her, without any research, can any of her critics name a single other case that they feel she ruled poorly on and was engaging in activist behavior? Can they name one? No, they can't. That's why you got comments like this. Again, we'll go back to Matt Walsh. He said, openly defy these judges. He's being very broad now. Some random federal judge, okay, has no authority. She's not the commander-in-chief. Ignore her and deploy them. It's time for a showdown with these activist judges. Okay? Like, he's not even being specific and saying, yeah, this one's actually a terrible one because back in this case, she ruled terribly, and she ruled terribly in this case, she's got to go. With other judges, that has been the case. Like, I believe it was the judge that let the in the case of, I'm trying to think of his name, the Charlotte stabbing. I can't remember the guy's name, but the guy that stabbed Irina. Like, people looked at the last judge that let him out, and they went back and they looked at some things, and they were like, here are some reasons to believe that she's not doing her job well. Okay, fair enough. That's fair. Go point to what they're doing, go back and look at some history and say, you know what? It looks like there's a case to be had here. Now, what about separation of powers? Well, here's a video of Stephen Miller, also a favorite of mine. That's a joke, people, just in case you didn't realize it. All right, so here's this case. I mean, okay, so it's a little hard to hear the reporter's voice because it seems like he's too far away from the microphone. But they're basically like, hey, are you recommending that the Trump administration, do anything in particular to the judge? He's just kind of asking this generic question about the judge and what Trump should do. So here's Stephen's answer.
No, it's simply a factually accurate statement that when a judge assumes for him or herself the powers that have been relegated or delegated by the Constitution to the president, that is a form of a legal insurrection, and we have seen. And legal weight. So are you recommending? No, we have seen over the last 9 months a ongoing legal insurrection in which district court judges, as a class, in many cases, have issued, which is why they've been overturned so much, have issued rulings that are flagrantly unlawful and unconstitutional. And it is an insurrection against the laws and Constitution of the United States. And we need to have district courts in this country that see themselves as being under the laws and Constitution and not being able to take for themselves powers that are reserved solely for the president. One more question.
Okay, so that's a lot of words to not say anything. So for starters, the judge didn't take any powers that are given to the president. If she had, what she would have done is been like, I'm going to move troops, or I'm going to order troops and demand that they stay home. That would have been assuming powers that she didn't have. What she did was put a temporary restraining order on the president's action. As a district judge in Oregon, as we've already demonstrated, was put in place by Congress. And what was it, like 1958 or whatever, right? Congress put her in. Congress put that court into place. Courts have federal courts have the power of judicial review. Okay, what that means is they can review things. Now we could do a whole episode on whether or not they should have judicial review and do they overstep their boundaries in that particular case. But right now, it's generally well understood and accepted that courts have the power of judicial review. Courts may decline, however, to review matters that they deem non-justiciable, or let me put it this way, that are deemed political questions, such as matters of like foreign policy or impeachment-related decisions, right? So they can decline. They can say, yeah, that's not something that we're going to deal with. That's a political question, okay? So they can do that. In this particular case, it's not just a political question whether or not Trump moves troops to engage in a particular action in a city. That's not a political question. That is a question of, is he exercising his authority appropriately? In areas like national security, courts often grant significant deference to the president. This isn't an issue of national security. Why? I don't know if you know this or not, but the issue in Portland deals with a singular, one single block. That's it, one block. That's where all the, and we're going to get into some more of that, and I think it'll make more sense why it's not really a national security issue. Now, it could be an issue, if the president said, hey, we need to send in more ICE agents to help, deal with some of the threats on our federal building, fine. No issues there, okay? But he's deploying troops, and there is a limitation on when the president can call up troops. He doesn't just get to call, like some people are like, oh, he can, it's a rebellion, which we'll talk about. It's a rebellion, so we just need to call up some troops. Like, it's not that easy. We have checks and balances on purpose. And then this one you may not know, any plaintiff that's bringing a case to the court, in this particular case, the plaintiff has to establish a clear basis for the court's authority to even hear the case. Do you know that? Yeah, you don't get any of that from Stephen because he's just giving you this mishmash of words to kind of make it out like, again, activist judges. So you might ask yourself, well, what are the options for a president if he believes a judge is overstepping their authority? Well, they have some, actually. They can appeal. So in this case, the president is appealing or he did appeal the temporary restraining order. They can also make a motion for stay pending appeal. They can make an emergency stay from the Supreme Court. And in more extreme cases, they can petition for writ of mandamus. That basically seek a rare, that's where they seek a rare extraordinary writ from the Ninth Circuit or Supreme Court to compel the judge, Immergut, to vacate the order. Basically say, hey, get a higher court to say you're exceeding your power, right? You're going too far. You need to vacate that. You're basically inventing a new law, right? There's a motion for reconsideration or clarification. That's where they file in a district court to amend the order, arguing that it's been a misapplication of the facts of the law, right, before the full appeal briefing. And then lastly, they can seek recusal. They'll be like, hey, for whatever reason, you need to recuse yourself from this case. And then another judge has to come in and make a different decision. They could ask Congress to impeach the judge. Have you heard any word about that? Nope. Like, if you listen to Stephen, then the real question should be, why isn't Congress, who's a Republican majority, why aren't they impeaching judges? If that's the call for it, if it's that big of a deal, if it's this ongoing legal insurrection, just making up terms, if it's an ongoing legal insurrection, then why isn't Congress starting to impeach any judges? I mean, we're asking questions, and the critics don't seem to have any answers. The Trump administration also can make seek legislative changes. That's where he would advocate to Congress for them to clarify or amend statutes like 10 U.S.C. 12406, which is the one that he's using to claim that he can call up the National Guard. Okay? So he can go and say, hey, would you amend this or would you clarify this so that judges will look at it and go, yep, the president is within his authority. Do you hear about that? Anybody calling for Congress to have an emergency session so they can clarify or amend it as needed? No. Why? Because Stephen is just bullshitting you. That's why. Don't let him fool you. Okay, now here's what the Trump administration has done. They filed an appeal, and they filed a motion for stay pending an appeal. All that really means, I'm going to break it down super simple. The appeal challenges the temporary restraining order's validity, basically saying, hey, this is not valid, while a motion for stay suspends the order until the appeal is finished. That's basically, so they've filed two things. They went through the legal process. They went through, and these are the standard legal processes that somebody would go through. So they didn't escalate. So I'm going to make this claim. I'm going to say, because the Trump administration didn't escalate beyond your standard legal procedures, they actually don't believe this garbage that they're selling you. They're just telling you this to make you angry. They're playing politics. Don't let them do that. All right, let's get on to the live chat. Let's see what you guys are talking about here. Let's see. All right. Some guy named Liberty Dad said, good morning, all. Good morning to you, sir. Let's see what else. Yes, my VA lady points out we're down the street. We have 4,000 more watch hours than what we did before last week. Liberty Dad is almost monetized on YouTube. Get those watch hours up, folks. Make sure you watch my show. Make sure you recommend it to some friends. If you have to, I know it's a tall order, but if you have to, grab your tablet while you're at work, fire up my one of my episodes and just let it play. It's not cheating if the ghosts in your house are watching it. Let's see. That's right. Liberty Dad will give you the straight dope, and I don't mean drugs, because drugs are bad, okay? Let's see. Nice shirt that DL is wearing. It is. I like it. Freedom over everything. That's how we roll on this show. Let's see. Tune in to the Kim Iverson Show exclusively on Rumble at 5 p.m. today for a major announcement from New York's hardest working libertarian, Larry Sharpe. Thanks for reading this, Liberty Dad, and thank you for the Rumble rant. That was a Rumble rant. See, I read the Rumble rants when you put them out there, guys. So yeah, check out Kim Iverson's show. Larry Sharpe's a friend of mine. He does some great work up there in New York. I was on his show actually a while back, kind of sort of debating, maybe just more of a conversation about immigration and the proper position for a libertarian. I was on there with Ben Weir. He's an anarchist. We had a great conversation. Ben Weir and I we didn't really disagree too much, but, we discussed our perspective on immigration. And then Larry, surprisingly, it was surprising. He dropped the hammer and he's like, here's the better position. And he kind of took my position as Ellis Island and he expanded on it, made it more of a free market position, for which I could not argue. I was like, well, yeah, it's still what I'm advocating for, just now in the free market. Gotta love that. So, hey, it's awesome. So check it out tonight, 5 p.m. Let's see what else we got here. Yes, Keith says the presidency has too much power, in my opinion. Likewise, Congress, though they have handed a lot over to POTUS, war powers and such. Yes, I agree. Congress has abdicated their duty. And here, I will make this argument. I will say, and the 10th Amendment Center backs me up on this. When the 10th Amendment Center agrees with me, I'm right. Okay? When they disagree with me, well, we'll deal with that when that happens. But they will point out that Congress cannot delegate duties, responsibilities that are specified to be under their authority. They cannot delegate them to somebody else because the Constitution does not allow you to delegate powers like that. So in other words, if the Constitution said this power is for the president can't be like, yeah, I'm gonna let Congress do it. No, it's for the president. And the president has to make that decision. And likewise, if a power is delegated, if the Constitution delegates a particular power to Congress, Congress cannot just be like, yeah, we're going to give it to the president. Why? Because that usurps our checks and balances. The Constitution is built on the design of checks and balances. That's how we have it. So if they want to make that, if they want to delegate that authority, they have to make an amendment first. That's what they're supposed to do. It's not what happens in practice. Why does it not happen in practice? Because we, the people, are not holding them accountable. That is why. So, just figured I'd go on that little tiny rant there. All right, folks, that's good for now. Freedom over everything. Speaking of, this comes from Maj Touré over at Black Guns Matter. So let me go ahead and dive into, let's play his quick promo here real quick, and then we'll get back and we're going to dive into this ruling. So we'll be right back.
What's up, Solutionaries? Maj Touré here, founder of Black Guns Matter and the Solutionary Center. We offer basic firearms classes, conflict resolution, and a whole host of other skill sets that are beneficial to our communities all around America. We're able to do these classes because of your voluntary donations. We don't accept government funds. The people that choose to pay it forward to remove the financial barrier to entry are choosing to do so voluntarily. So you can support at givesingo.com/solutionary. Give it whatever level you can afford to do. Repost the content. Let folks know that we have a community to save and we have to do it ourselves together. givesingo.com/solutionary. Be safe, be solutionary.
All right. Man, that's pretty cool that Maj is wearing the same shirt that I am. I'm just going to say, I think he's trying to be like me. That's all. That's all I'm saying. I'm going to clip this. I'm going to put it out there, just tag him just for fun. All right, let's get into this. So we need to talk about this ruling. So I'm not going to put it up on the screen just because I find that it's too difficult to put the PDFs on the screen. But I'm going to read some stuff to you, okay? So let's get to the very beginning here. Well, before we do that, we're going to narrow this down to 3 primary areas because it is a 31-page document. I can't read the whole thing to you because that would be bloody boring, okay? We're not going to do that. But I'm going to focus on the stated facts of the case, focus on rebellion, because she talks about rebellion in there, and we're going to talk about the 10th Amendment, okay? That's what we're going to focus on. So let me read from the very beginning here, because a lot of people are like, oh, it's these activist judges, they're just ruling. Okay, well, in order for you to say an activist judge, they need to be doing activist things, which means there's some underlying reason why they're doing it, okay? If I'm an activist, like if I'm an activist and I go out and I throw paint on a painting in a museum, besides the fact that that's completely wrong and I should go to jail for that. But if I do that, I have some underlying reasoning. And if somebody says, well, why did you do that? I might say, well, I wanted to bring attention to global warming or whatever, and I'll give you my rationale. So here is what Judge Immergut says. This case involves the intersection of three of the most fundamental principles in our constitutional democracy. The first concerns the relationship between the federal government and the states. The second concerns the relationship between the United States Armed Forces and domestic law enforcement. The third concerns the proper role of the judicial branch in ensuring that the executive branch complies with the laws and limitations imposed by the legislative branch. Whether we choose to follow what the Constitution mandates with respect to these three relationships goes to the heart of what it means to live under the rule of law in the United States. Does anybody out there in internet land, did anybody hear that and say, that sounds like a leftist activist to me? Anybody? Because it doesn't sound like no activist to me. This is on page 2, by the way, if you want to read it. And it's in the show notes. I encourage you to go read it. It's 31 pages. You could probably read it on your lunch break. All right? Now, between pages roughly 5 and 15, you have the stated facts on the ground of Portland. So I'm going to give you a summary of those. I'm not going to try to read it because it's like 10 pages. That would be crazy. Okay? So all in all, it identifies that about 40 people were arrested in these protests. There were about 10 protests specifically specified, like actual dates. On this date, about this many people were in protest. This happened. This many people were arrested. So you had about 10 protests. And of all the protests, it ranged from somewhere between 30 and about 200 people. That's where your protests were, okay? Now, that doesn't mean that if there were like 200 people there, that all 200 people were burning stuff down and rioting, okay? Those are the BLM riots. That's a different story, okay? We're talking about here in Portland, okay? There were, but it specifies. So if the critics want to say she's wrong, they should read the ruling and they should say, well, it looks like the ruling said on this particular date that so many people were there and that 4 people got arrested for doing this. And they should be able to go back and look at news reports or do a Freedom of Information request and say, all right, police department, the PPD, the Portland Police Bureau, like, we would like to know what were the facts that you have documented for a particular protest on a particular date, right? Does that match up with what the judge wrote? Does the Trump administration, do they have a different account? Where are they getting their information if it differs? If, you say, hey, on this particular date, this thing happened, this many people were there, this many people got arrested for doing this thing, okay? Does the Trump administration concur with that assessment of a particular protest? If they don't, then we have to get to the bottom. Why is there a difference? A significant difference. I mean, if it says like there were 30 people there and the Trump administration said there were 35, that's not a sufficient difference. But if Judge Immergut says, hey, on this particular date, there were 40 people in attendance at this protest, and the Trump administration is alleging that there were 100 people, well, that's a huge difference now, right? That's significant. That requires some looking into, okay? Because again, we want to figure out what are the facts on the ground, because the facts on the ground will determine whether or not we believe that the situation was bad enough that the president might need to actually send in troops. All right, so we'll go on here. Let's see, protest summary. Let's go to page 10 here real quick. I'm going to jump over to page 10. Here is something that was interesting that caught my attention. There's a couple things here. Let's see here. One, it said the protest generally, so it says from July 18th to September 27th, Central Precinct police officers handled the ICE protest with routine monitoring. The protests generally were limited to fewer than 30 people and were largely sedate. Like, they were basically chill. They weren't problematic. Okay? Well, okay, so there's some facts here. Were they generally limited to fewer than 30 people? Or were they regularly attended by more than like 100 people? That would be a big difference. And that would be a problem in this ruling because the facts on the ground are not being stated correctly. And were they largely sedate? Like, were they, like, elsewhere in this ruling, they call them mostly peaceful. I hate that phrase because they used it during the BLM riots. Like, they would be literally on the news, and they're like, these protests are largely peaceful. Why, there's like a car burning behind them. I'm like, that doesn't look peaceful at all. Okay. And there was like $1 billion worth of damage. That's not largely peaceful. Now, you might say it's largely peaceful if you say, okay, well, yes, there was $1 billion of damage, but the amount of damage that could have been caused by the sheer numbers in attendance. But then I would say it's time to use a different phrase. Okay, in that particular case, if that's the argument that you're making, which I imagine that might be kind of like what the media was hiding behind. But in this particular case, I would say if the protests were so few in number, somewhere between 30 and 100, and they were largely peaceful, then I would assume that means, if we're going to be reasonable and objective, I would assume that means in each protest, the number of people that were arrested were very few, 3 to 4, somewhere around there, and the number of people that needed to be arrested matched the number of people that were arrested. In other words, if you say there's a protest of 50 people, 4 people got out of hand and they got arrested, but the other, let's say it's 5. What number did I say? If I said 50 people, if it was 50 people and 4 got arrested, then the other 46, well, they were peaceful, right? Then I would say, okay, maybe it is reasonably, you could reasonably say it's largely a peaceful protest, okay? But it also depends on what those 4 people did. Like, if those 4 people did, like, if they threw a bomb, at a federal building and blew it up, then I'm going to say, like, that protest is kind of no longer largely peaceful. So you see, it's a matter of how we use the language, right? But we need to have the facts on the ground so that we can determine whether or not this phrasing is accurate, whether or not it's appropriate. So it goes on and it says, if the protest were to increase or threaten public safety, PPB could call on additional available resources. And the ruling discusses what available resources what resources were available. But the protests have been such a minor issue that the normal nightlife in downtown Portland has required more police resources than the ICE facility. Okay, that's a fact that you can argue. And you could say, like, are the drunks out there causing more of a problem than these protesters at the ICE facility? That is something that we could concretely look at and evaluate. Have you heard anybody that's calling for the Trump administration to ignore judges or calling the judges activists? Have you heard any of them talk about this or these kind of facts, right? At all? No, you haven't. That doesn't mean it's not happening. I'm just saying maybe we don't listen to them until they do. All right, continuing on. Now, let's see here. Page 15. Let's go to page 15 here. And I want to read this here. So here's where the judge talks about the plaintiffs. Plaintiffs bring claims alleging that defendants, that's the Trump administration, actions violate, 1, the statutory authority granted the president in 10 U.S.C. 12406. He either violated it or he did not. If he violated it, what do the critics say should be done? How that should be how should it be handled? If Portland believes, or Oregon, whichever, if they believe that Trump is violating his own authority, if they can't go to judges because they're activist judges, what are they supposed to do? Where do they go? Well, how do they handle that? Right? Let's skip whether or not we think that the president was in violation or not. Let's just say when somebody believes that government is violating their authority, how the F are they supposed to handle it if people on the right are busy just going, "That's an activist judge because they didn't give me the ruling that I wanted"? By the way, if this had went to the court and the same judge had ruled in favor, would they be saying activist judges? Would they be saying they're out of the scope of their authority? No, they wouldn't. If it was the Biden administration and he got told no, would they be like, man, these activist judges? No, they wouldn't. They're only saying that because their boy didn't get the power he wanted. Continuing on. Number 2, and this is the allegations from the plaintiffs. Number 2, Oregon's sovereign rights as protected in the 10th Amendment are violated, right? The Posse Comitatus Act is violated. The Administrative Procedures Act is violated. And the separation of powers as well as the militia and take care clauses of the U.S. Constitution are violated. That's a lot of claims. Now, maybe they're wrong on all accounts. It's very possible that they're wrong. It's how court cases go. You come in, you make a claim, you're either right or you're wrong. Or you're right with some, some caveat, or you're wrong with some caveat, right? But effectively, you're either right or you're wrong. And so, what is Oregon supposed to do if they believe that their sovereign rights have been violated? If they believe there's a 10th Amendment violation, where do they go? Do they just call up the Supreme Court and say, hey, make a cool ruling? No, there is a process. They go to the federal court first. The federal court makes a decision. If the federal court, if it makes a decision and somebody believes that they're absolutely wrong, then they can make an appeal. And then they appeal to a higher court. And then eventually they get to the Supreme Court. It seems like either these influencers don't understand how our system works or they don't care. Which is weird because they're saying the judges don't care about how our system works while they're busy not caring how our system works. You see the problem here, folks? Do you see why I'm hitting them so hard? Do you see why it's so important to actually read the rulings and demand that your favorite influencer or your least favorite influencer actually reads them before they spout off nonsense to all of their followers who will then run with this nonsense thinking that they know what they're talking about, and yet nobody is actually talking about what's in the damn document. Crazy, huh? Let's talk about rebellion. I believe I saw somebody, I don't have the tweet available. I think it was Will Chamberlain. He's also a big influencer. He said, oh, we're an open rebellion. Well, fun thing, because that's addressed here too. Okay? So I'm going to read this to you. It's from pages 23 to 26. I'll try to read it fast and not take too long. Okay? Defendants also argue that the September 28, 2025 federalization order is authorized under subsection 2, which permits federalization of the National Guard in response to a, quote, rebellion or danger of rebellion against the authority of the government of the United States. Okay, end quote. Let's see. The parties disagree about the meaning of the word rebellion in the statute. Interpretation of a word or phrase depends upon reading the whole statutory text, considering the purpose and context of the statute, and consulting any precedents and authorities that inform the analysis. That comes from Dolan versus United States Postal Service, so it's prior court ruling. Additionally, courts must interpret words in statutes consistent with their ordinary meaning at the time Congress enacted the statute. That also, they're citing from prior court cases. Okay? The Ninth Circuit Court did not reach the government's rebellion arguments in Newsom 2. In Newsom 1, however, the district court performed a detailed statutory interpretation of 12406. That's the statute that Trump administration used to say we can call up the National Guard. Okay? That this court finds instructive. There, the court surveyed 4 dictionaries from the late 1800s and early 1900s when Congress passed the first predecessor statute to 12406, the Militia Act of 1903. So now this judge is going and saying the Ninth Circuit Court consulted 4 dictionaries between the 1800s and 1900s so they could see what did rebellion mean at the time that the statute that said you can call up the militia, the National Guard, in times of rebellion. What did the word rebellion mean? Okay? And let's see. And they go on and they say, from that survey, the court identified several shared characteristics of a rebellion, as Congress would have understood the term in 1903. First, a rebellion must not only be violent, but also be armed. Second, a rebellion must be organized. Third, a rebellion must be open and avowed. Fourth, a rebellion must be against the government as a whole, often with the aim of overthrowing the government rather than in opposition to a single law or issue. Well, that's interesting. The court also considered three of the same definitions that parties here proffer from the current edition of Black's Law Dictionary. Okay, and then she lists those. Even overlooking the problem, however, defendant's definition of rebellion also contravenes the greater statutory context of 12406. The Ninth Circuit defined the statutory phrase, unable with regular forces to execute the laws of the United States. I'm trying to skip over some of the legal stuff here. The way that legal documents and rulings are worded sometimes are complicated to read just to an audience. I'm trying to skip over those parts, but also give you the useful parts. So going down here, therefore, this court reaches the same conclusion as the district court in Newsom 1, that the following key characteristics provide the boundaries for what constitutes a rebellion. So again, first, a rebellion must not only be violent, but it must be armed. Second, a rebellion must be organized. Third, must be open and avowed. Fourth, must be against the government as a whole, often with the aim of overthrowing the government rather than in opposition to a single law or issue. So if people like Will Chamberlain or Matt Walsh want to say, hey, this protest is an open rebellion of the whole government, or let's just back it up. If they want to say it's open rebellion, then they need to provide a better definition of rebellion that matches our precedent, our history as a nation. You can't just go making up words, or maybe not making up, but making up definitions for words. That's not how our law works. And I will also point out this, for those of you that might remember my episode that I did where I talked about constitutional interpretation, and we talked, we bounced off of Antonin Scalia's speech that he gave on the topic. He is a constructionist. If you don't know what a constructionist is, that is somebody that says, what did the words mean at the time that they were being used? And then you go back and you look at those words, right? That's what Antonin Scalia was. If you don't know Antonin Scalia, you should, but he was basically the darling of the right. Not always. Sometimes he made them upset too, because he was a good justice, right? But people on the right tend to prefer, like if you want to think of judges in terms of left and right, people on judges that are deemed to be on the right tend to prefer constructionism. They tend to prefer going back and looking and saying, what did this word mean when it was used way back when it was put into statute or into law? What did this word mean? And then they go and they say, is that what's happening today? If not, then they say, sorry, there's not a violation, or there is a violation depending on the case. You see the issue here? People on the left, or judges on the left, tend to be associated, this is not always the case, but tend to be associated with something called the living Constitution. The living Constitution is where you say, well, we need to redefine the Constitution in terms of today, meaning words might change their meaning. And then the word rebellion meant one thing back in the 1900s, but today in 2025, it means something different. So that is how we will apply the law. It's kind of weird, right? Because the right is doing what used to be associated with the left. Amazing things you can learn when you read. Let's get on over to the 10th Amendment violation here. Let's see where we'll go for that. 10th Amendment. Let me see if I can. I think I might read. We'll see. Defendants, ultra vires, federalization of Oregon's National Guard troops also violates the 10th Amendment. The 10th Amendment reserves to the states all rights and powers not delegated to the United States by the Constitution. The Constitution grants Congress the power to, quote, provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Insurrections and invasions have very specific definitions. We should probably go back and find out what they meant at that time and then determine, are they applicable today with what we're seeing. This is why the facts on the ground matter. Okay? Here, because the president is acting outside that delegation, he is taking measures incompatible with the expressed will of Congress reflected in that statute. Okay? So, therefore, the president lacks constitutional authority to federalize the National Guard once he exceeds the constitutional authority that Congress granted him, such as in Section 12406. Okay? This is probably the part that I should have read. I'm trying not to make it confusing, and this part I maybe did a little bit lackluster job of preparing for. I apologize. Because the president is federalizing the Oregon National Guard absent constitutional authority, his actions undermine the sovereign interest of Oregon as protected by the 10th Amendment. Oregon has a 10th Amendment power to control its National Guard to the extent it is not cabined by the militia clause. And as discussed above, defendants have acted outside the scope of this constitutional authority conferred by Congress. Put another way, defendants interfered with the constitutional balance of power between the federal and state governments by federalizing state National Guardsmen for federal service when no statutory or constitutional authority permitted their federalization. That was the argument. The argument was, Trump, you violated, or you're trying to violate, the 10th Amendment by federalizing the Oregon National Guard. That is either true or it's not true. Has anybody like Matt Walsh, Will Chamberlain, or any of the other buffoons out there claiming that, that this is something that the president has, have they come in and clarified and said, this is how the president is lawfully, constitutionally exercising this authority? Because if they had, they would first have to consult the facts on the ground and say, the facts on the ground are this. Because of that, we are therefore permitted to do this. That is how it works. And we talked about the facts on the ground. You had some 40 people were arrested. There were about 10 protests that ranged between 30 and 200 people. They were focused explicitly on the ICE building, right? They were disruptive. Don't get me wrong. I'm not laying cover for them. From what I read, the people that were arrested were rightfully arrested. They should have been, because they were going far beyond protesting. And you can protest. You could protest when the government's doing the right thing. Doesn't matter. You could protest the people that got arrested. That's legitimate, right? There's nothing wrong. But the question is, did the protest get out of hand? A good question to ask, as the judge here pointed out in this document, were the protests in general, not one-offs, but in general, so much out of hand that they actually exceeded the nightlife? That's a hell of a question. Can any of them answer that? Because if the nightlife required more police resources or more law enforcement resources than did the protest overall, right, then it's hard to argue that the president was within his authority to go and say, we're going to call up the National Guard against your will, and we're going to send them in there to protect this building. Because if they're protecting the ICE building under those pretenses, then why were they not protecting the nightlife? Arguably more important. Are not citizens more important than law enforcement officers from the federal government? I would argue yes. Yes, they are. If they're under threat, they are more important. Civilians are more important than our military while under threat. Because, civilians have limitations, right? They don't have backup. They don't have all kind of guns and armor and blah, blah, blah. So hopefully I've made the case here that people don't know what they're talking about. They don't know what they're talking about, mostly because they didn't read the ruling. And it's very clear when they're posting on social media whether or not they've read the ruling. It's very clear. Now, Stephen Miller probably did read the ruling. He probably just doesn't care. And his job is basically to make up nonsense to try to get you on the Trump administration side. That's kind of his job, essentially. That's what he's doing, all right? And we should call him on his bullshit, plain and simple. All right, let's get to some comments here, and let's see what you guys are saying in the chat. Maybe you guys are correcting me left and right. That's cool. I'll accept some corrections here. Let's see what we got here. All right, get back to where we were. So Trump is more charismatic, has more charisma, less capacity now that his age is affecting him. Needs to get more AIDS. Yeah. I mean, kind of. I mean, and I'm not going to hold that against him. I mean, the man's like 80 years old. You're just not as good at communicating at 80 as you were at like 50 or 60, or even 70. Hell, even just a couple of years ago. I mean, as you get older, you rapidly decline. It's just the nature of things. It's cool. I'm okay with that. Like, he's not as good although I will say this. He's not doing too bad for being 80. He's doing better than Biden. That's for sure. Let's see. Keith asked, politicians are mostly truthful? Mostly not. Let's see. MK Ultra, welcome. Good to be here. Carlin was on here the other day. Thought I would check out the no-nonsense libertarian snapshot of these incidents, considering the propaganda levels are outrageous on both sides now. They are. I can't even keep up with this nonsense. It's just, and like, look, I get it. We're all going to come with a little bit of embellishment. Even me, right? Like, I'm America's most objective libertarian, because I said so and I objectively made that claim. But even I make embellishments from time to time, right? But at least there should be a foundation of factualness. I think it's a word. There should be a fact-based foundation. And a lot of times there's not. And how do we get to a better society if we're not even dealing with the facts, at least on the foundation of our embellishment? I get it. It's a rough world out there. We're all trying to communicate, trying to get people's attention. So we say crazy things, but the crazy things should have a foundation in truth. Truth that we have read and evaluated objectively. Let's see what else we got here. Let's see. Yes. So some quack, I think is how you say it. You want to see activist judges, plenty of rulings in Oregon on guns that could show them to you. Now I'm not going to, I guess we have to define what it means to be an activist judge. I don't have a definition that I can readily call up. But I will say this. Yes, I will disagree with judges all the time. I have disagreed with judges that I like. I have disagreed with judges that I dislike. I'm reading things and I say, okay, do I agree with the judge's assessment of this? Where it might come into activism, I think, is when you cannot point, and this is not I'm just kind of making a quick, brief, ad hoc definition kind of. But I would think that at least part of it would have to do with, okay, we can see that repeatedly this person has been on one side and that they've repeatedly violated, say, the Constitution, or they've repeatedly made bizarre rulings. Okay. Now, if they make some rulings here that are good and some rulings here that are not so good, I'm not willing to call that activism. Maybe not a good judge, right? Because I think that's the thing that we forget. We not everybody's an activist necessarily. Sometimes people just aren't good at their job. And is that the case here? I don't know. I haven't, this is literally the only ruling that I've read from this judge. Now, yes, earlier I did say that all gun laws would, in my opinion, be a violation of the Second Amendment, right? But even still, you could argue and say it's not yet risen to activist level if at least they make an interesting argument. Interesting argument doesn't mean it's correct. We can say, well, that's an interesting argument. Here's where it's wrong, right? And I think we should. We should say, well, here's where it's wrong. And nice try, not activist, but still wrong. So, yeah, I agree. And I don't disagree that there aren't activist judges necessarily out there. But I think before we make that claim, we go through a reasonable process. And we say, yeah, I've read enough of your rulings. I think this is why I think we can't even leave it at the level of you're just not a good judge. We have to escalate it and say, okay, we're elevating this from not a good judge to activist judge. And I think we need to have clear lines for that. Because otherwise, we're just shooting from the hip. And I don't shoot from the hip. I try not to. In person, I might. If you say something mean to me, I might shoot from the hip and be like, rah. Let's see. Yes, both sides love to change meanings of words when it helps them get ahead. It's true. And that's why we, as the population, need to start reading some of these documents and go, whoa, 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 hold up. You're on the other team, but you're wrong. Or you're on my team and you're wrong. Like, you can ask my audience. If you're new to the audience, you can ask my audience. They'll tell you, I will hold my own team accountable, libertarians, just as much as I hold the Republicans accountable, just as much as I hold Democrats accountable. That's why I don't have that many friends, okay? Because I'm busy holding everybody accountable for things. So if you have a lot of friends in politics, I don't know. Maybe evaluate whether you're doing it right. I'm just kidding. You can have friends. Let's see. MK Ultra says, haven't they for some time now, and now they have a compromised legal system? We do have a compromised legal system, I think. I think we need to, for a variety of reasons. One, we've got a lot of bad case law, in my opinion. Two, we've got bad lawyers out there. We've got bad judges out there. But most importantly, we have a bad population that has kind of allowed it to happen, right? I think that's our biggest reason. Because again, I go back to, I said this, I think, yesterday on the show. I said, as a libertarian, the bare minimum for what you accept from governance should be the Constitution. After that, it should be it should not come as a surprise to anybody that many libertarians would be more strict on government than the Constitution. But we should, at a bare minimum, be at the Constitution. And I feel like we've gone way far from what the Constitution was intended to provide us. And that is because we were given a republic and we have not kept it, as Ben Franklin once said. We have not done a good job of keeping it. We have allowed the powers that be to distort it in so many different ways. So many ways. It's bad. Let's see. Okay, that's some conversation in the chat there. Okay. All right, I think that's it for me. So that's a wrap for this episode. Hope you found it informative and inspiring. Whether you're watching me right now or later, come back and drop a comment. Let me know your thoughts. Maybe as you're going about your day, you think of something new and you're like, you know what? Let me go tell that DL something. Maybe I missed something. Maybe you need to help offer, you need to point out somewhere where I need to offer a correction. Or perhaps you just want to be promiscuous with praise. You want to come in here and you want to say, DL, I was thinking about it, and man, you did such a good job, and you're so brilliant, and you're so awesome, and you're objective. You're basically like a kingly judge, right? I'm all ears for all of that, or whatever you give me, okay? But with that, for now, I'm out, folks. I will see you tomorrow. You know that I'm all about supporting organizations that hold my values. Make sure you head on over to blackgunsmatter.shop. They've got apparel, stickers, and more. Use the code LibertyDad, all one word, at checkout to score a 10% discount. Or just hit the referral link in the show notes. That'll make it so much easier. Remember, I'm not just a voice on a mic. I'm a dad who's working hard to deliver to you the best libertarian content. Connect with me on Linktree, where you'll find links to my Patreon and buy me a coffee, because every bit helps keep this show rolling. Plus, you can find me on my other platforms to stay in the loop. With your help, this show, The Message of Liberty, will be seen and heard by more people. As always, I appreciate you tuning in and look forward to seeing you in the next episode.